who are the traitors and who are the patriots?
This in your file.
Senator, again, I think that this, as a judicial nominee, it would be inappropriate for me to comment on the topic of controversial subject matter, and I have apologized for...
Unbelievable. I mean, I'm asking you, you'd retweeted something, all right? You made an active decision to amplify a tweet. You thought other people should see it. That tweet included patriots and traitors. So I'm asking you, when you retweeted that, who in your mind were the patriots and who in your mind were the traitors?
Senator, I don't have any context for that, and I have apologized for retweeting.
You for context. You did this. You did it. You hit send. So who are the patriots and who are the traitors?
And Senator, I don't have an answer for you.
Unbelievable. It's impossible for me to understand this. I mean, you worked for a client on a policy that has been determined to be unconstitutional. You had a right to do that. Obviously, the president made his decision. You were his advocate. But now you're on a court where that court and the Supreme Court has said those are unconstitutional, and there's going to be questions about refunding those tariffs. In fact, there are questions about that right now. And you can't just make a clear expression to us about whether you would or would not recuse yourself when you were on both sides of the issue.
A woman being considered for a lifetime federal judgeship just sat in front of the United States Senate and said out loud, on the record, that she has no answer. Not that she misspoke, not that she changed her thinking. No answer. She retweeted a post that sorted Americans into two categories, patriots and traitors. She chose to amplify it. She pressed send, and when a senator asked her to explain what she meant by that, she said she had no context. No context for her own public action. That is who we are talking about today. But here is what makes this hearing genuinely dangerous and not just politically embarrassing. Because before we even got to the tweets, Senator Welch had already built a conflict of interest case that should have stopped this nomination in its tracks. She worked inside the Trump White House on tariff policy. The court she is being nominated to, the Court of International Trade, ruled those tariffs unconstitutional. The Supreme Court confirmed that ruling, and there is active refund litigation sitting in that court right now. She could end up ruling on the financial consequences of policy she helped create. And when asked directly whether she would recuse herself, she could not give a clean answer. Two separate problems, one nominee, one hearing room. I want you to watch the entire thing from the beginning. Because the Patriots and Traitors moment is not even the most alarming part of what happened inside that room. Watch how this builds.
The record before Senator Welch speaks, supporting Ms. Lane's nomination from 33 current and former state solicitors general and other members of their senior staff. They happen to praise Ms. Lane for her, quote, rare combination of intellectual rigor, practical insight, careful attention to details, qualities essential for a federal district judge, end quote. They also highlighted her, quote, ability to manage demanding caseloads, develop persuasive legal arguments, and engage effectively with courts and opposing counsels. Without objection, that will be entered into the record. Senator Welch.
Thank you, Mr. Chairman. I want to follow up on Ms. Westercamp on this conflict of interest question and recusal. I mean, you worked, of course, in the White House, and you worked on the trade policies and the tariffs. Is that correct?
Senator, I worked on, as I disclosed in my Senate Judicial Questionnaire, various executive orders and proclamations.
You had nothing to do with the tariffs?
Oh, we don't open.
Senator, some of the executive orders, as I said, executive orders related to trade and tariffs.
Right. So, and that was obviously an enormous pillar of the Trump policy. Tariffs are really, really important to the administration, as you know. The court that you'll be serving on, should you be confirmed, found that those were unconstitutional, correct?
The CIT, with the three-judge panel, yes, held that it was unconstitutional.
Right, and the U.S. Supreme Court affirmed that decision and said the CIT decided correctly, correct?
That is correct, Senator.
All right, so just explain to me how there's any question about whether you should recuse yourself. You worked in the White House, where a major policy of the White House was the promotion of tariffs, and now you'd be sitting on a court where they found those tariffs unconstitutional. And should there be further litigation about these tariffs, you cannot tell us today whether you would recuse yourself in view of the fact that you were an advocate for the tariffs in one case and now you'd be on a court that found those tariffs to be unconstitutional?
Again, Senator, I would take recusal very seriously. In terms of recusing for any matters, executive orders that I worked on, I believe the president had actually revoked those executive orders via another executive order after the Supreme Court's IEPA decision.
It's impossible for me to understand this. I mean, you worked for a client on a policy that has been determined to be unconstitutional. You had a right to do that. Obviously, the president made his decision. You were his advocate. But now you're on a court where that court and the Supreme Court has said those are unconstitutional, and there's going to be questions about refunding those tariffs. In fact, there are questions about that right now. And you can't just make a clear expression to us about whether you would or would not recuse yourself when you were on both sides of the issue?
Senator, I think it would not be inappropriate to grade my own work, so to speak. And so, yes, I would, for specific matters that I worked on in the White House, would recuse myself. And I would add that the refund litigation is actively before, I think it's Judge Eaton in the Court of International Trade. And so it would be inappropriate for me to comment on how that is proceeding.
Stop right there. Because what just happened in that exchange is something most people are going to scroll past without fully registering what was said. She confirmed she worked on executive orders tied to tariff policy inside the Trump White House. She confirmed the Court of International Trade, the exact court she wants to join, ruled those tariffs unconstitutional. She confirmed the Supreme Court upheld that ruling. And then when pressed on whether she would recuse herself from future tariff-related litigation, her answer was essentially, some of those executive orders were revoked, so maybe it won't come up. That is not a recusal answer. That is a deflection dressed up in legal language. Here is why this matters. A federal judge's obligation to recuse is not just triggered when they personally feel conflicted. It is triggered when a reasonable outside observer would question whether that judge can be impartial. The standard is the appearance of bias, not just the reality of it. And when a nominee worked inside the administration that built the policy and the court she wants to join already struck down that policy, and the financial fallout from that policy is currently being litigated in that same court, a reasonable outside observer does not need to think very hard to see the problem. She said she would grade her own work. That phrase should have landed harder than it did in that room, because that is exactly what recusal rules are designed to prevent. You do not get to be the one who decides whether your own prior work creates a conflict. That decision belongs to the institution and to the public trust that institution is supposed to protect. Senator Welch called it impossible to understand, and honestly it is, but keep watching, because the conflict of interest section was just the setup. What comes next is the part that is already everywhere online.
I want to ask you about a couple of tweets. George Papadopoulos, who tweeted out, there are but two parties now, Traitors and Patriots. And as you know, he's a former advisor to President Trump. And my understanding is you retweeted that out. Did you do that?
Senator, I don't have Twitter in front of me right now. I take you at your word that I had tweeted that. And as I stated previously, I think that retweeting from people that I don't know, including the gentleman you just mentioned, is an inappropriate way to express oneself on any controversial political or just matter.
Retweeting is an indication that you want to amplify what you read in the tweet, right? That's why people retweet. Correct?
Senator, I believe so.
Right. Well, who are the traitors and who are the patriots?
This in your file.
Senator, again, I think that this, as a judicial nominee, it would be inappropriate for me to comment on the topic of controversial subject matter, and I have apologized for...
Unbelievable. I mean, I'm asking you, you'd retweeted something, all right? You made an active decision to amplify a tweet. You thought other people should see it. That tweet included patriots and traitors. So I'm asking you, when you retweeted that, who in your mind were the patriots and who in your mind were the traitors?
Senator, I don't have any context for that, and I have apologized for retweeting.
You for context. You did this. You did it. You hit send. So who are the patriots and who are the traitors?
And Senator, I don't have an answer for you.
Unbelievable. On November 14th, you retweeted a post by an account @CamVTV. The tweet read, in part, quote, "Big distinction between us and the party of hate."
You have the final.
Who is the party of hate?
Senator, again, first of all, I'm out of time, but I also, as I said, don't agree with everything that has been retweeted in the past.
Do you agree with anything you did in the past? You have to figure that out.
Senator, as to your specific question, I don't have an answer for you.
My time is up. Thank you, Mr. Chairman.
Ms. Lane, when she was asked this last question, so I would give you an opportunity to respond to Senator Coons's comments if you want to take advantage of it.
Thank you, Chairman Grassley. At no point in any of my representation in any litigation that I've been involved in have I ever been held in contempt, sanctioned, or formally rebuked by a judge. In a letter that was submitted to this committee, it referenced litigation that I was involved in, and that was in a state trial court. I was an attorney tasked with defending the state of Montana, and the trial judge went out of his way to say that the attorneys in the case had done nothing wrong and had complied with all of our legal and ethical obligations. And I appreciate the opportunity to clear the record.
Okay. Now the meeting is over.
All right, let's go through what just happened in that second half, because there are layers here that deserve a slower look. First, the George Papadopoulos retweet. For anyone who needs the context, Papadopoulos is a former Trump campaign advisor who pleaded guilty to lying to the FBI during the Mueller investigation. He was later pardoned by Trump. He is not a fringe internet account. He is a named, convicted, pardoned political figure with a documented history inside the Trump political orbit, and Westercamp retweeted his post, a post that explicitly divided Americans into two groups, traitors and patriots, meaning if you support the tariffs, you are a patriot. If you do not, you are a traitor. That is the content she chose to amplify. Welch did not ask her whether she agreed with Papadopoulos as a person. He asked her a much simpler and much more direct question. When you retweeted that framing in your own mind, who did you consider to be the patriots and who did you consider to be the traitors? And she said she had no context for it. No context for her own retweet of a post she sent to her followers. That is the answer she gave inside a Senate confirmation hearing for a lifetime judicial appointment. And then Welch moved to the second retweet, a post that referred to a party of hate. He asked her who she believed the party of hate was when she amplified that post. Her answer was that she does not agree with everything she has retweeted. And that answer, that single answer, opened a door that she clearly did not want opened, because Welch walked straight through it. Do you agree with anything you did in the past? And she said you have to figure that out. That is her answer to a senator in a confirmation hearing for a federal judgeship. You have to figure that out. Now I want to be precise about something here, because precision matters in a conversation about judicial nominees. Retweeting a post is not proof of judicial bias. It is not grounds for automatic disqualification. What it is, especially when combined with the conflict of interest questions that preceded it, is a pattern of public action that a nominee cannot or will not explain. And that inability to explain your own public record is directly relevant to the question of judicial temperament. Because judicial temperament is not just about how you behave on the bench. It is about whether you have the self-awareness, the discipline, and the accountability to sit in a position of enormous institutional power and be transparent about who you are and what you believe. She failed that test twice in the same hearing, once on policy, once on tweets, and both times her answer was some version of, "I cannot explain this to you right now." That is the record that now follows her into whatever comes next, and here's the part I want to sit with for a moment before I close. Ms. Lane, the other nominee in this hearing, used her closing opportunity to clear her own record regarding past litigation. She addressed it directly. She cited what the judge in that case actually said. She gave a clean, accountable answer. I am not making a broader argument about Ms. Lane's nomination from that, but the contrast inside the same room on the same day is worth noting. One nominee was asked hard questions and answered them. One nominee was asked hard questions and repeatedly said she had no answer. The committee will decide what that contrast means, but the public record is now clear about which answer was which. Senator Welch said one word when this exchange ended: unbelievable. And he said it quietly, not in outrage, not performatively, just unbelievable. And that quiet version of the word is somehow heavier than if he had shouted it, because it means even he, a senator who has sat through hundreds of these hearings, could not fully process what he had just witnessed. A nominee for a lifetime federal appointment sitting in front of the United States Senate, telling them twice that she simply does not have an answer. Federal judges serve for life. They do not face re-election. They do not hold press conferences. Once confirmed, the mechanisms for accountability are almost non-existent outside of impeachment, which means the confirmation hearing is not a formality. It is the only real moment of public scrutiny this nominee will ever face, and she used that moment to say she had no answer. If you think that should concern people regardless of party, drop a comment. If you think the conflict of interest question alone should have ended this hearing differently, tell me below. And if you want to see more of these hearings covered the way they actually happened, you know what to do.